Hi, folks. Good afternoon. I'm Ron Barriere from Burns & Levinson, a law firm in Boston, and with me is my partner, Cece Van Tine. Cece and I are going to give a presentation today about family abuse, particularly in the context of divorce cases. Now, I want to give you a little bit of background about who I am and who Burns & Levinson is, and then I'm going to ask Cece to do the same. So again, my name is Ronald Barriere. I'm a divorce practitioner. I've been practicing primarily in the area of family law for about 20 years now. In my entire career, I've worked with a talented group of lawyers at Burns & Levinson, which is a large law firm in Boston. And at Burns & Levinson, we handle just about all aspects of family law representation, including divorces, post-divorce cases, guardianships, probate litigation, as well as some estate planning matters, and how those actions interplay with divorce is kind of our area of expertise. With me today, again, is my partner, Cece Van Tine. Cece, why don't you tell our attendees a little bit about yourself as well?
Thank you, Ron. Good afternoon, everybody. As Ron said, my name is Cece Van Tine. You'll probably see it on the screen as Carolyn C. Van Tine, and I expect everybody can probably deduce how I got the nickname Cece. I am also an attorney at Burns & Levinson, and I'm also a divorce attorney handling all aspects of domestic relations and family dissolution or reintegration. I've been an attorney since 1993. Prior to becoming a divorce attorney, I worked for many years as an assistant district attorney in Brockton or Plymouth County, and certainly part of my focus at that time was in prosecuting domestic violence cases, as well as sort of all of the attendant cases that one may not consider a domestic violence case, but certainly had at their root abuse and domestic violence. And so that's my background. I've been charged in our list of things that we're going to do today with running through the disclaimers. So the first disclaimer may seem obvious, but is important, and that disclaimer is that Ron and I are lawyers. And we've just told you we're lawyers, so why am I saying that? I'm saying that because I want to make sure that people understand that we're not mental health professionals, we're not therapists, psychiatrists, psychologists, and nor are we members of law enforcement or in any way involved with domestic violence beyond the fact that we engage in helping people get divorced and to have a real understanding for how domestic violence impacts that process. But our limitations are how we come at that, right? We're coming at it as an attorney and not from a therapeutic care or safety focus. The second disclaimer is that family law is a state law. And what that means is that each state has a different set of laws. So if you're watching, I know we have a number of viewers, and I don't know where you all are coming from. If you're watching this from California or Colorado, you're going to want to double check what we say against your local law, because Massachusetts may differ, probably does differ in many respects, both from family law and also, as a side note, criminal law. So that's the second disclaimer. And the final is just that, you know, there's only so much time that we have, and there is so much information, and we may sort of get off topic. People may chime in with a chat question. I'm not sure if that's what we do today, but if they do, we may end up cycling sideways to cover something that's really important to people, and we won't cover the breadth of the information that is out there. It's impossible to do. So what we've done, and by we, I mean Ron, because he's the guru behind acquiring this information, is we've included at the end of this broadcast a list of additional resources that are available to you to sort of noodle around and find answers to questions. In addition, I'm confident that somewhere in this, and I'm not the techie person, somewhere in this will be our contact information. And if you have additional questions that you just want to bounce off of one of us, I'm sure our emails are going to be there, our phone. Don't hesitate to call or write and say, I was listening to that broadcast, you looked great. I think that's required. You need to throw that in there. But I do have this following question. So those are the disclaimers.
So yeah, I mean, just to piggyback on a point that Cece just made, look, this is a big topic area, and there are many facets of family violence. We're only going to have time to touch on primarily one aspect of family violence, and that's the interplay between domestic spousal abuse, which is our primary area of focus today, and how it interrelates with the divorce case. So again, you know, to Cece's point at the end of this presentation, I will post a list of resources that are available to folks who want to learn more about family violence, including the other forms of family violence, elder abuse, child abuse, and neglect. So the primary forms of domestic and spousal abuse are physical and sexual abuse, neglect, verbal abuse, and intimidation. And each one of those has several subcategories. And the common forms of physical or sexual abuse are parent to parent, parent to child, and increasingly so in recent years, child to parent. Unfortunately, those are all manifest in a lot of divorce cases, not just in Massachusetts, but throughout the country. So people need to be able to recognize the signs of those forms of abuse. Neglect is also a common form of abuse. And neglect can take many forms: withholding of necessities, including food, clothing, and shelter, economic abuse, isolation, and toleration or condonation of physical abuse by third parties. A common example of this last aspect is, again, increasingly in the form of abuse from a child to a parent, with the other parent either condoning it or simply looking the other way. Probably the subject area that bears the most exploration during this call, and that Cece and I frankly have the most extensive experience with, is the interplay between economic abuse and isolation. The reality here is oftentimes in the division of labor, and even an intact family, parties take on different roles. One party will be primarily responsible for managing the finances, and the other parent will primarily be responsible for managing the children. In cases of that kind, oftentimes the abusive spouse develops, frankly, a kind of a territory over the economic aspects of the marriage. They oftentimes can not only withhold money, food, clothing, shelter, and actual cash, but they can also withhold information about those resources. So one of the things that, you know, people need to be mindful of if they are either suffering from spousal abuse or they know someone who is, and they're looking for a lawyer to help either themselves or their friend out of their situation, is you want to look for a lawyer who's versed in these concepts, because, you know, lawyers like Cece and I, we have extensive experience in knowing not only the signs of abuse, but also the signs that we need to look out for in furtherance of finding out the information that could be being withheld. Information about bank accounts, information about cash that may be being held in other countries, information about transfers of large portions of cash or other assets. Cece and I and lawyers at Burns & Levinson, we know how to go after that information, all of which is necessary for people to have a full analysis of their situation prior to a divorce, okay? Another common form of abuse is verbal abuse, and sometimes these can be obvious, such as name-calling or threatening behavior, and sometimes they can be more subtle, such as gaslighting or negging. You know, gaslighting is a term used to identify situations where people are kind of subtly demeaning the other person and making that person doubt whether or not they're actually experiencing what it is they perceive they're experiencing. They fear oftentimes that they're crazy. And gaslighting is a form of abuse that oftentimes an abusive spouse will use in order to make the victim of abuse less likely to report what it is that they're experiencing, because frankly, they're doubting they're actually experiencing it at all. Negging is another form of gaslighting. Negging oftentimes is one of the signs that's most easily recognizable to third parties. Negging is a form of, you know, kind of backhanded compliments, or, you know, a pattern of condensation or mean-spirited joking directed at the victim spouse. Oftentimes this occurs in public, whereas most other forms of abuse are more insidious. They take place behind closed doors. Negging can actually happen out and about. It can happen at a dinner party. It can happen, you know, during phone interactions when one party's at work. And oftentimes it has a cumulative effect on the victim. You can actually see them start to kind of be weighed down under this kind of repeated form of abuse, which is condescension. Intimidation. Intimidation is also generally present when one of the other forms of abuse are present. Intimidation can be, you'll be nothing without me. You'll be left alone. You'll be bereft of information. You'll be bereft of money. You won't be able to support yourself. You're nothing without me. And sometimes that message isn't articulated verbally. Sometimes it's articulated based upon the interplay by other forms of abuse that we've been here discussing. So, Cece, why don't we talk a little bit more about that form of abuse, which is the withholding of resources and the withholding of information, and how we as lawyers can kind of attack that?
Okay, great. It is one of my more favorite topics. I did want to sort of highlight, as a part of sort of under the umbrella, if you will, of economic abuse, which is sort of this withholding of resources as well as withholding of information, kind of dovetails with the verbal abuse of the name calling in sort of a pattern of denigration that I think that people experience who have been denied access to the funds or to the information about the funds. And what I mean by that, and I'm sure some people this will resonate with either from themselves or for somebody that they know, is when somebody is denied access to the money, they're forced to go and ask for money. They're forced to, they're given a budget, which is in and of itself can be incredibly demoralizing and is insulting. And at the same time as they're being denied the information, and when they seek that information, they're being denigrated about it, is this sort of balance of power issue that I think you're going to hear throughout the broadcast today. And that manifests itself in this instance with the idea that the person who has the economic control is somehow in a higher level than the person seeking some access to that control. And the denigration can take place with name calling, with you're not good enough, you don't earn enough money, you're not contributing, which again cycles back to the idea that maybe somebody would be afraid to leave because they doubt their own value, financial or otherwise. Once the person realizes that maybe I can leave, maybe there is hope for me to get out of this relationship, and they seek the assistance of counsel, such as ourselves, it becomes incumbent upon us to figure out where all of the information is. And we'll give a person at the outset, and if there are practitioners watching, I recommend coming up with a questionnaire. We have them, questionnaires that sort of send the people off to look for whatever information they can access. And then if there's information that they cannot access, we have the tools to get the rest of the information and put that puzzle back together. And one of the resources that we use for that, for putting the puzzle back together for people who have been denied the information, have been denied the money, and perhaps are wrought with self-doubt as a result of years of abuse, is we employ the assistance of financial planners as well. So in a broad way, we as the practitioners can do the discovery to determine really how much money is in the marital estate and how much income a recipient spouse would be entitled to, which are two important things that you would want to know at the beginning of a divorce or during the process. How much income am I going to have going forward on my own, and what are my assets? But sometimes, in addition, the financial planner will be able to tell you long-term whether or not this is going to be enough, that you're going to be okay, because you're going to want those independent voices while you're relearning your own voice.
Yeah, I mean, just to piggyback on a point that Cece made, and I think bears repeating, sometimes people come to us and they say, look, I don't even know what it is that I don't know. Part of our job as lawyers is to say to them, that's okay. It's okay to say, I don't know. That's an acceptable answer for us. We would rather you tell us you didn't know, so we know to go look for it, than to try to make it up or guess. It's okay for you not to know. It's okay for you to tell your lawyer, I don't know the answer to this question, because we know how to get the answers to those questions through the discovery processes and through the means such as the use of financial planners in order to make a long-term plan that's going to benefit our client throughout the divorce process and after. So if you're out there and you're wondering whether or not you yourself are suffering from some of those more insidious signs of abuse, or if someone that you know and care about is suffering from some insidious signs of abuse, these are the things that I would recommend that you look for in terms of trying to find those kind of signifiers of someone who's been subjected to them. The first and most obvious is disclosure. If the person says that they're suffering from abuse or that they're living with an abusive spouse, if you care about them, start by believing them. Start by validating what it is that they're saying. Because one of the hardest things for people who are subjected to abuse is the feeling of isolation, the feeling of loneliness, the feeling that they're in this by themselves. And if they have someone that they trust enough to disclose it, it's our duty to support them and to hear them out and to care about what it is that they're saying and help them through the process, because they're trusting you. And it takes a lot of strength in order to disclose being the victim of abuse to anybody. And if they're disclosing it to you, well, then you should step up and help them. Some of the other signs of abuse are physical signs of trauma. This is, one of the more obvious examples, obviously bruises, cuts, but also physical signs of internal trauma. People who have repeated complaints of stomach issues, people who repeatedly talk about general soreness, limited mobility. Oftentimes these are more manifest in elderly patients, but they can be manifest in younger clients as well. Some of the behavioral signs of abuse are changes in work performance, home avoidancy. If someone is repeatedly talking about a reluctance to go home, a desire to stay out, a desire to be away from their spouse, that can often be a sign of abuse. Uncontrolled anxiety, being hypervigilant, hyper alert, or hyper watchful. A parent appearing either particularly aligned with the other side, i.e. the abuser, or more often the case with a child, being almost codependent with a child. These oftentimes are signs of someone who is being subjected to some of those more insidious signs of abuse. So now, I think it's important that Cece and I talk a little bit about the ways in which abuse can impact the divorce process itself. So the first subject heading we have here, Cece, is biases. They work both ways. For the viewer who can't get a full sense of Cece and I through these tiny little boxes on your Zoom screen, I'm 6'1", 200-pound bald guy. I recognize that I present a certain way, and it is important that I am aware of how I present to clients, especially to victims of spousal abuse or domestic violence when they come into my office, because I can be a big intimidating presence, and a big intimidating presence doesn't always fit for people who have been subjected to spousal abuse. And I think, Cece, you and I were talking a lot about this prior to today's presentation, but how do you think biases play into the representation of a client who may or may not have been subjected to spousal abuse?
Well, I think it's a great point, and it's an interesting one that I don't think you hear raised very often, this idea of bias, and that sometimes bias is okay because it's just an inherent part of how we function. And when it comes to people who may have been subjected to domestic violence, I think there's probably two ways that people can go. One is to sort of gravitate towards someone they may perceive of as sensitive, which for a lot of people may mean that they seek out a woman as an attorney. Perhaps they think that that's a person who would be more able to understand them. They'd be maybe perhaps more comfortable to recount the instances of abuse. However, I think that it is just as likely from my own experience that people may feel comfortable that the first time they go into court against someone who terrifies them, to have the 6'2", 220-pound bald guy next to them, because that's a physical barrier, like an actual physical barrier between them and the abuser, which has value. And I think the point that we're trying to make relative to bias is that that's okay. And in this instance, especially at the beginning of a divorce, even if there were not domestic violence, but in this instance, especially in a situation where there's domestic violence, it's all hands on deck. It's no matter, you are looking out for you at this point. And that means that if you feel that, if your gut is telling you that I really feel like I'm not going to be able to tell a man everything that's happened to me, well, then go hire a woman. Don't think, well, I don't want to be biased. Go and hire that woman. Or if you feel that your husband will intimidate verbally, physically, intellectually, will intimidate a female attorney, even if that isn't true, if that's what you feel and believe, go get the man that is going to make you feel like you're getting all your tools, every single tool. Your attorney is a tool, your financial planner is a tool, your friends are tools, your photocopying machine, your computer, all are tools that you're going to use in order to fight this battle. And so don't hesitate to follow your gut for what you think is going to be the best resource. The only other thing I will say, apropos of bias in this instance, is you will note that when you begin the process that your spouse or your client's spouse will have perhaps engaged in the same, I don't know, it's the same thing, basically, either consciously deciding, well, I don't want to appear misogynistic. I want people to think that I would never be abusive. I'm going to hire a woman. Or I don't want to appear that I hate men if it's a woman who's the abuser, and I'm going to hire a man, or I'll hire, right? They may themselves have consciously or subconsciously gone through the same selection process. And it's just a data point. There's nothing you can do about it, but it's just an interesting thing to sort of have in the back of your head when you're navigating this.
Yeah, and you know, I want to circle back to something you said that I think is so important, that when people come into my office, and I know you feel the same way, what we're looking for is a level of rapport with the client, because they are entrusting us as lawyers with really sensitive information, not just about abuse, but about their finances, about their children, about their family situation. So it's very important that they feel a sense of trust and comfort with us as practitioners. And that actually benefits us as practitioners as well, because we know that the client has developed a significant enough rapport with us that they can tell us all of the things that maybe they don't want to tell everybody else. So that bears repeating. And you know, one thing that you said that I agree 100% with, CC, is this kind of all hands on deck approach that you referenced before. And one of the benefits of working at a place like the place where you and I work at Burns & Levinson is that we have lawyers from all different backgrounds. We have men, we have women, we have lawyers who went to Ivy League schools, we have lawyers who went to state schools, we have lawyers who have kind of a direct approach, we have lawyers who have a higher kind of more intellectual approach to taking on representation. And one of the things is sometimes when a client is working with me and I don't feel like I'm serving all their needs, I'll bring in CC, or I'll bring in another one of my partners or an associate to help with the case in order to say, I think you're a better fit for this client than even me. And you know, that's one of the luxuries that we have as practitioners at Burns & Levinson, that we can afford clients that opportunity. So let's talk about some more practical things. Legal consequences. Obviously, disclosure of abuse has criminal ramifications. It can result in the issuance of a restraining order or potential criminal charges issued against the abuser. That can be obviously a point of leverage in a divorce case. It would be folly for us not to acknowledge that those points of leverage do exist in a divorce case, but it can also result in some kind of practical considerations that need to be considered as well. Cases can be being litigated in two different courts. For example, restraining orders and criminal charges are oftentimes handled by the district court. Restraining orders also have concurrent jurisdiction with the probate and family court in Massachusetts, which is the court in which most divorce actions can take place. So if there's a crisis issue in a domestic relations context and somebody contacts the district court and the district court issues a restraining order, then they contact a divorce lawyer like CC or I, and we're representing them in connection with the divorce case in the probate and family court. Well, they have litigation going in two different courts, and that's something to be cognizant of. And you know, luckily, both CC and I have extensive experience in both courts, and most of the lawyers at Burns & Levinson do as well. Custody and parenting time. CC, I think we should talk a bit about how the presence of domestic violence in the home can impact custody and parenting time. So would you mind speaking on this point, subset number 2 here?
Sure, not at all. Be happy to. So some of this may be self-explanatory, but I'm a linear thinker, so I'm going to say it anyway. Obviously, one of the biggest sort of victim groups in a domestic violence situation, even if they're not the initial target, are the children who of the parties. And by that, I mean, even if a parent thinks that they're only directing their rage at their spouse, or the other parent thinks, well, it's only directed at me, the kids aren't being victimized. And the reality is that they are, that children who are living in a home or an environment where one person who they love, in many cases, is hurting the other parent who they love. And that is an unimaginable situation for them. And so even in those situations, how do you deal with parenting? How do you deal with custody? And another term for parenting that some people use is visitation. We don't, because it has all sorts of connotations that we could talk about in another webinar, but not here. But when I'm referring to parenting time for some folks, what I mean is what other people back in the day, the old-timey phrase was visitation. And so the question is, if I have a client who has been the victim of domestic violence, what do we do about, and we'll say that mom is the victim and dad is the abuser. What do we do about dad's access to the children? And there's different accesses, like is this a child who shouldn't be with father unless the time is supervised? When will it become unsupervised? What will supervised time look like? And when that time goes from supervised to unsupervised, what's the process that is going to be engaged in? What other professionals are we going to need to assist with that? This is when we decide, when are we going to employ therapists for the children, investigators, in order to determine what the level of abuse has been and what impact it has had on the children. All of those come into play. And the cases are easier, and please imagine the quotes around that. They're easier to define if the domestic violence is the sort of classic cut and dried repeat beatings, multiple times that the police have been called to the home, hospitalizations, that type of thing. Those are the cases that are pretty, would be in our realm, as cold sounding as it is, straightforward. The cases that are less straightforward are the cases where the abuse is, as we had on earlier slides, more insidious, that the children have watched one parent denigrate the other parent for years. And how do we handle the parenting in those situations? Or how do you handle the parenting in a situation where the children have watched it and in sort of a Stockholm syndrome effect have bought into it and believe the press that the abusive spouse has sort of initiated? And we've dealt with all of those cases, and there are ways of handling all of that, but it's difficult, right? And for some folks, I think it's the thing that keeps them from leaving the marriage, this thought that everybody believes this, and I can't leave my children alone, subjected to that. So what do I do? And I urge people, even if you're not ready to take that real initial step down the road to divorce, if you come and speak to an attorney such as ourselves or someone else just for information, they'll be able to tell you that you shouldn't be as scared as you are. Now, we haven't walked in your shoes, so it may not have much meaning, but you should get that information. And you'll see up on the slide, or you would have seen up on the slide, I'm a slide behind, the legal custody issue is part of this idea of, oh, slide came back, B. If you see 2B, you'll see physical custody and parenting time. I've already talked about that. And then there's also legal custody. And legal custody is just the ability to decide where the children are going to school, weigh in on their religious upbringing, and weigh in on medical, non-emergent medical issues. And typically, in cases where the parents, maybe they don't care for each other, but there is no abuse, it is typical that it's a shared arrangement. Both parents get a chance to have a say in how the children are being brought up in those areas. But now the question is, now there's domestic violence. If there's a restraining order in place so that the parties can't communicate, how do we handle that? If there isn't a restraining order in place, if the communication, even during the divorce, when the lens is being shown on the person so clearly, and one person cannot communicate with the other without being a horrible human being, how do you handle the communication? And so that may be one of those areas where we would say to the court, listen, and at least now, mom or dad, whomever we have, needs to be the sole legal custodian because these people cannot communicate. And so that's one of those other areas that's impacted by domestic violence.
Yeah, and I think, to Cece, to your earlier point about, sometimes it's a little more cut and dry when we're talking about manifest physical abuse. In manifest physical abuse situations, almost invariably, it is going to be supervised visitation. What we need to be on the lookout for is cases where the abuse is more insidious, to your point. And whether that has been passed on to the child, forms of disparagement, repeated condensation, those things can actually, condescension, I should say, those things can kind of manifest themselves in more insidious ways, and it's not necessarily as obvious as to whether or not supervised visitation should be in play. And we are always kind of cognizant of those points when we're dealing with our clients. But another thing that I think bears even more emphasis that you raised is the concept of confidentiality. Okay, this presentation, we don't know who you are, folks. We don't know who you are if you're watching this. If you want to speak with a lawyer like Cece or myself, make an appointment, come in and talk. As lawyers, that meeting, even that first initial meeting, it's confidential. We can't talk to anybody about it ever. You can feel safe to communicate with a lawyer if you have concerns about the divorce process, getting information about the divorce process, or if you're actively shopping for a divorce lawyer to assist you in connection with your abuse case. That initial consultation, just like all further consultations, are confidential. We can't talk about it with anyone else. So you should feel comfortable in reaching out to a lawyer and getting information that you may need. So we've talked a little bit about some of the practical realities of visitation and parenting time on children, but also the presence of domestic violence can have an impact on the allocation of assets as well as other financial aspects of the case. In Massachusetts, there is a contemplation in our divorce statute, which is in Massachusetts General Law 208, Section 34, that an abused spouse sometimes can be allocated a greater share of the marital estate due to the particular circumstances of the divorce. And also, sometimes in certain circumstances, they may be awarded additional alimony by virtue of the fact that the sustained abuse could have limited their economic opportunity to go out and earn an income of their own and become self-supporting. So these are things that you should talk about with your divorce practitioner in furtherance of how the economic impact of a divorce interplays with the presence of domestic violence. We already discussed that litigation may be impacted because multiple courts may be involved, as well as the impact of discovery. A guardian ad litem. A guardian ad litem is a court-ordered investigator who is often appointed in cases where there is either domestic violence presence between the parties or directed at one of the children. Guardians ad litem are often appointed for the purposes of assisting the court in getting to the heart of the matter. They're very common to be appointed in divorce cases involving custody of children, and they're very likely to be appointed in cases where there's domestic violence present. So there's additional limitations on how a guardian ad litem goes about his or her practice in cases where domestic violence is present. We've kind of highlighted them here on this, this overview. There's also some basic safeguards that are contemplated by statutory protection in Massachusetts, whereby addresses, phone numbers, places of work can be safeguarded from an abusive parent in the divorce context or in the post-divorce context as well. So there's actually options on many of the court pleadings to keep information about a victim confidential so that it doesn't get disclosed to an abuser. All right, one of my favorite topics, is there any hope of settlement in cases where domestic violence is present? Cece, I'm going to let you sell this one.
Well, I think we can everybody can guess what the answer is. Yes. I'm not the one who created this slide, but I will agree with its author that it should still be everybody's goal to settle the case. And so here's my mini soapbox. I think that every case people should at least try to settle. And it may be that it just isn't the right venue, but it should be at least something that everyone should want to consider. And the reason that settlement is the most advantageous route to divorce for any participant is because it is the least expensive and it is the least emotionally taxing. You cannot, putting it another way, it's going to be emotionally taxing no matter what, even in a settlement posture, but it is less draining than contemplating going into court. Sometimes you have to go into court, and attorneys such as Ron and myself are a great resource for preparation for court, etc. But not having to deal with that extra added bout of stress is huge for people who are already perhaps grieving the death of their marriage or struggling with regaining the confidence in order to be able to do this. If you can avoid court, I would say avoid court within reason, and your lawyers will tell you that. So putting that to the side, putting the fact to the side that we all believe that settlement is the most important because it is less expensive, because it is you can get things done more quickly, and because you're actually maintaining power, right? If you enter into an agreement after negotiation, you have control over the process in a way that if you leave it to a judge who is a neutral and is a great person and was well regarded when they were in private practice, you're still leaving it to someone with their own inherent bias that may or may not jive with yours, and in addition, may or may not get you that result for months or even years. So if you want to at least try to get an agreement, I think it's well done of you. The concern for a lot of folks is that when one is a victim of domestic violence, there is a balance of power issue. How am I going to get that settlement where perhaps I don't have the same level of information as my spouse, as we talked about the economic abuse. I don't trust my own voice. That's a huge one. In my practice, I see frequently people coming in, whether it's about economics, parenting, whatever it is, or if it's about everything. They have been subjected, they've been in a foxhole, taking on enemy fire for so long, they don't trust their voice. And so how do you send someone who doesn't trust their voice to go into a mediation solo and negotiate? And obviously you can't, but there are ways to get the person to the point of being able to negotiate that may not involve mediation. And now the next screen is mediation, and I'm going to turn it over to Ron.
Yeah, so I mean, mediation is, Cece just touched upon it, mediation is a very favored form of dispute resolution in Massachusetts, increasingly so given the limitations on access to the court due to COVID-19. But the value of mediation really is that parties get to take control of their own destiny. Well, the mediation process in Massachusetts is, requires both parties to have full access to information and to have kind of equal footing going into the negotiation process. That can be very impractical and sometimes impossible in the abuse context, because first of all, in mediation, oftentimes people are in the same room. If one party has significantly greater access to information and resources than the other party, they can use that in order to kind of gain advantage. So, skilled mediators, and there are a number of skilled mediators in Massachusetts. I do mediation. Cece, I know you do conciliation. Do you do mediation as well?
I don't. And as a quick aside, I'm just not, I was trained to do it. I work with my clients who are involved in mediation. I sort of define myself as a divorce coach in that arena. I'll prep them for each of the meetings. But when I did the mediation, I found that I was just more, I'm wired as an advocate, and it was a real struggle for me to maintain neutrality throughout and I was like, I did it, but I did not enjoy it. So it's not in my wheelhouse.
But you know what? That's an excellent point, because it goes to our earlier point about biases. You know who you are, and you know how you best are able to resource the client. But in terms of mediation, I do mediation. And one of the things that I recognize is, frankly, when there is an abuse context, or when there's an allegation of abuse, I'm frankly much less likely to go into mediation in the way I ordinarily do. I will generally put up all kinds of limitations about it. Oftentimes in cases where I'm asked to be a mediator, I won't do it unless there are lawyers who are representing both parties, because of my recognition of the inherent imbalance of power that can exist in the abuse dynamic. But mediation is not impossible. It's not impossible in the abuse context. It just needs to be looked at with some level of scrutiny. And again, you want to make sure that you're communicating with a skilled divorce practitioner in terms of finding out whether or not that mediator has the capacity to run a tight ship and keep the process as controlled as possible in order to protect the victim. So here are some resources that CC and I were able to put together for folks who are viewing at home. These are all excellent resources for people who want to learn more about domestic violence in the home, both in the divorce context and outside of the divorce context. And to CC's earlier point, folks, we are happy to help you answer any basic questions that any of you may have about the process in general, or about our practices in particular, or about Burns and Levinson, because this is hard stuff and this is sensitive stuff. And you want to make sure that whoever it is that you're reaching out to has the level of know-how and experience in order to kind of marshal you through this difficult time. So Cece, did you have any closing remarks before we kind of open the floor up to questions?
Well, okay, well, you're just gonna, I was saying my closing remark was that I saw a question in the question and answer thing. But my other closing remark, is I was worried about it. I was like, what do I do? There's a person who needs information. But just to your point, I know I mentioned it earlier and you just said it, but just to echo it, that even if it's whoever you reach out to get information, don't feel badly that you're seeking that information. Even if you think, I don't know that I'm ready to get a divorce. I don't know if divorce is the answer. Maybe you're still hopeful that there's another answer for you. I think that getting information, there's value in it, no matter what you do with that information. I would never want someone to think, well, I don't want to be a bother, or I don't want to waste somebody's time. The reality is that it is so important to get information. And when you meet with folks like Ron and myself and others, certainly, we have the information and we can steer you in the direction that you want to go. If where you want to go is to marriage counseling, we'll steer you in that direction. We have great marriage counselors, and candidly, I love working with marriage counselors, especially in the arena of domestic violence, because in the event that the marriage cannot be saved, that the violence isn't changing, that the abuse isn't changing, the denigration isn't changing, it's still a place where the parties can go in order to learn how to be to co-parent into the future. Now, obviously, that's not as effective in the true violent situations, but in many cases where the violence is the more insidious, or the name calling and that type of thing, to have somebody maybe try to work with the parties to teach them how not to treat each other, even in the divorce context, it has value. So please don't hesitate to reach out to a divorce attorney for resources.
Now, Cece, I see that we have a question from one of our viewers asking about if we could spend a little bit of time talking more about emotional abuse. We're happy to do that. Emotional abuse can be in multiple forms. It can be withholding of affection. It can be withholding of information. It can also be in the more kind of obvious forms of name calling or negging or general condescension. All of these are different forms of emotional abuse. Oftentimes people are concerned about whether or not they're actually experiencing, what they perceive as emotional abuse is emotional abuse. Well, look, if you perceive it that way and you don't feel safe enough to talk to your partner about whether or not this can be addressed, it's a form of emotional abuse. I mean, the reality here is you need to be able to have a loving and trusting relationship with your partner. And if you're concerned enough about it that it's bothering you and you're thinking about it on a daily basis and it's impacting your life performance, you should probably speak with a skilled divorce practitioner or a therapist, mental health therapist, in order to help you through those feelings. Because the truth is, if it's lingering, if it's bothering you and it's persistent and it's not going away, it's something that should be addressed.
Ron, the only thing I'd like to add to that, because I couldn't agree more, and when I was listening to you talking, the thing that popped into my head, and of course you got it first, but I'm going to say it again anyway, is the idea of also employing or reaching out to a therapist. If you don't have one already, I can't overemphasize, I am bullish on therapy, especially in a divorce, even if there's no domestic violence. But just having that independent mental health professional to bounce things off of and tell you and mean it, that how amazing you are and how you will survive this and be better for it is worth its weight in gold. And especially in this instance, relative to sort of the verbal abuse that the questioner was talking about, because to Ron's point, when you've been taught to question your own voice, then you're going to question whether or not it's verbal abuse. And one of the things that Ron highlighted earlier in the seminar is the other issue that I view, and as does he, as the sort of the other spoke in the verbal abuse wheel, and that's the gaslighting, which is the other sort of area where people are really going to doubt their own voice. And gaslighting, and I'm sure if folks go online and noodle around, you'll see is sort of a part and parcel with the narcissistic personality. But there are many personality disorders that employ gaslighting. And not every abuser has a personality disorder, which I know is kind of shocking, but some people are just horrible, right?
Jerks,
and
right.
they're just jerks. But but gaslighting is where people will really doubt, say, oh, don't say that to me. I didn't say that to you. And after a long time, you're not going to believe it. So if you're not ready to ask a divorce attorney a question because you're not ready to contemplate divorce, or you just can't even imagine it, at least seek out a mental health professional who can help you navigate getting back to that place where you're able to stick up for yourself and for any children, and hopefully, make the right choice for you for the rest of your life.
Yeah, and again, there's therapists, just like lawyers, are beholden to confidentiality arrangements. So, there are ways in which you can cover your tracks if you're concerned about being found out about seeking out help, paying in cash, using third parties to help you in order to do that. And frankly, consultation with a divorce professional, we can kind of help you figure out other ways to do that. But also, if there's a trusted family friend that you can talk to in furtherance of steering you in the direction of getting the professional help that you need, I would recommend you at least seek that out as well. All right, folks, I see that our time has come to a conclusion. Thank everyone for watching. Thank you, Cece, for your excellent advice and guidance on this very sensitive topic. And if anyone has any questions, please feel free to reach out to either Cece or myself or any of the talented lawyers at Burns & Levinson. And we'd be happy to help you through this very difficult time in your life. Thank you, folks.
Thank you.